Hello and welcome to this, our first installment of seminars in Davis Blank Furness's Commercial Landlord and Tenant series. The series is designed for surveyors, property agents, in-house lawyers and landlords and tenants themselves to assist them navigate the world of commercial landlord and tenant matters. My name is Sean Hackett and I'm a partner and the head of the Davis Blank Furness Property Litigation Department, and over the next 6 seminars I will be focusing on commercial lease termination and renewals under the Landlord and Tenant Act 1954. So let's get started. Today we are laying the essential groundwork for the first installment before looking at the foundation stone itself, and our focus will be on the Landlord and Tenant Act 1954, which I will refer to as the Act, and to security of tenure under the Act, and the ever-present question: should you keep it or contract out of it? Understanding the initial principle of statutory protection is vital for anybody involved in the letting or occupying of commercial premises, as it dictates the manner in which leases come to an end. I start by highlighting a distinction between a tenancy and a lease, as many people use the term interchangeably. The tenancy is the creature created in law. That is what comes into existence between the landlord and the tenant. The lease is the document which records the terms of the tenancy. A tenancy can therefore be created where there is no lease, and we will say more about periodic tenancies later in our series. So let's begin. Commercial tenancies form the backbone of business operations, from retail shops to office spaces to warehouses and leisure facilities. The Act was introduced to protect tenants from arbitrary evictions by their landlords, thus promoting stability in a post-war economy. The Act dates back to 1954, with significant updates in 2004 via the Regulatory Reform Order, which simplifies procedures like contracting out, which I will come on to shortly. As of 2025, the Law Commission is reviewing it further, but no major changes have been implemented yet. At its heart, the Act provides business tenants under a qualifying tenancy in England and Wales with what is known as security of tenure. This is a statutory right under sections 24 to 28 of the Act. In simple terms, it means two key things. The first is that a business tenant has an automatic right to renew their tenancy at the end of the fixed contractual term stated in the lease. Their tenancy does not simply end on the fixed expiry date. Instead, it continues on the same terms until it is terminated in a very specific way, which we will cover in Seminar 2. The continuation is referred to as holding over. The second is, should the landlord want to regain possession of the premises let to the tenant, they can only do so on one of 7 specific statutory grounds set out in the Act. These are narrow grounds which we will explore in detail in seminars 3 and 4. It is not enough for a landlord to simply want their property back. They must have a good reason recognised by law. The policy behind this is to protect the investment that the tenant has made at the premises, fitting it out, as well as the goodwill the business has built up at its premises, because a business location is often integral to its success. A common misconception is that all leases automatically benefit from the Act, and that isn't the case. Part 2 of the Act applies to what it calls a tenancy, where the property is or includes premises which are occupied by the tenant for the purpose of a business carried on by them. I will refer to these as qualifying tenancies. For there to be a qualifying tenancy, 3 key elements must be met. The first is that there must be a tenancy. This is the creature that I mentioned earlier, which is usually signified by the existence of a lease. The second is that the premises must be occupied, and that's a question of fact. The tenant does not have to be there 24 hours, 7 days a week, but it must be their business address and they must be conducting substantial activity from it. The third is that the occupation must be for the purpose of the tenant's business. This must be the business of the tenant and not of anybody else. So if a tenant company allows another company to use the space, that doesn't count. The Act therefore covers most standard business uses, for example, offices, shops, workshops, warehouses and surgeries. The Act doesn't apply to residential leases or tenancy agreements or agricultural holdings or mining leases or certain licenses, or as we will come to later, those tenancies which have contracted out of the Act. It also doesn't apply to tenancies for 6 months or less, but these are rare in the commercial property context. The Law Commission has suggested that the 6 months be extended to 2 years, but this has not yet been enacted. For tenants, security of tenure provides commercial certainty. They can invest in fitting out premises knowing they can't be easily removed. For landlords and their agents, the automatic protection afforded to tenants where they can hold over after the contractual term in the lease has passed can create significant problems. It restricts flexibility. A landlord may want to redevelop or take on a different tenant at the end of the tenancy, but the Act means that the landlord might be stuck with the existing tenant. An example will help illustrate the point. Let's imagine a 5-year tenancy expired, say, 2 years ago. The tenant remains in occupation, not confirming whether it is prepared to accept the terms of the new tenancy which the landlord is offering. But because of the Act, the original lease terms continue to imply indefinitely. The tenant continues to pay rent, but at the rate set by the lease entered into some 7 years earlier. This means that the landlord is locked into an old rent, which is likely below the current market rate. They cannot regain possession easily because they're tied to the existing tenant occupiers, and they are stuck with lease terms which may be outdated or no longer adequate owing to changes in legislation. So what can a landlord do? The solution is to create a tenancy that is outside of the security of tenure provisions of the Act. This is universally known as contracting out. A contracted out tenancy is one where the landlord and tenant agree before the tenancy commences and the lease is signed that the tenant's automatic rights to renewal and protection will not apply. In practice, this means that where the tenancy has been contracted out, firstly, the tenancy will terminate absolutely on the expiry of the contractual term stated in the lease, i.e. on a fixed date. There's no possibility of holding over. The second is that the tenant has no right to seek a new tenancy. The third is that the landlord can plan with certainty, knowing that they will get their asset back on the fixed date. And the fourth is that the tenant has no statutory right to remain in occupation. If they do stay in occupation of the premises after the fixed date has expired, they're a trespasser and the landlord can seek a court order for possession. For a landlord, this is often the preferred position, particularly for short-term lets of a few years or where they have specific development plans for premises. Now, whether a tenant will be prepared to take a contracted out tenancy or insist upon the tenancy having security of tenure under the Act, in practice comes down to the respective bargaining powers of the landlord and the tenant. Now, this is the most critical part of today's session. A landlord and tenant cannot simply state in the lease that the parties contract out of the Landlord and Tenant Act 1954. Because a tenant who is prepared to contract out of their security of tenure is giving up a valuable right, the Act sets out a very strict non-negotiable procedure that must be followed. If the process is not followed exactly, the contracting out will not be effective and the tenancy will be protected regardless of what the lease says. The procedure is set out in section 38A of the Act, and it has 3 key steps, which are, firstly, landlord's warning notice must be given. Secondly, the tenant must make a tenant's declaration. And the third is that a provision must be stated in the lease. And I deal with each of these in turn now. So dealing with step one, the landlord must serve a formal notice on the prospective tenant. This is often called a simple warning or a Section 38A notice. The notice must be in prescribed form or substantially to the same effect. It must warn the tenant that the tenancy is about to enter into will not have security of tenure. It must explain the consequences of that in clear language, and the tenant must receive this notice before the tenancy is entered into and the lease signed and becomes legally binding. The second step is that after receiving the notice, the prospective tenant must either make a simple written declaration that they have received the notice and accept the consequences, or swear a statutory declaration to the same effect before an independent solicitor or commissioner for oaths. The simple declaration is used if there are 14 days or more between the notice being received by the tenant and the lease being entered into. The statutory declaration is used if there are fewer than 14 days between the notice being received by the tenant and the lease being entered into. Crucially, the declaration must be made before the tenancy is entered into and the lease signed and becomes legally binding. And the final step is that the lease itself must contain a statement either in the body of the document or endorsed on it that confirms that the parties have complied with the statutory procedure and that the tenancy is therefore outside of the Act. If any of those three steps are not followed, then the contracting out process will be ineffective and the tenancy will have the statutory protection under the Act. The question is, for landlords and tenants, from a strategic point of view, how do they decide? Well, this is a key question point for discussion between clients and their advisors as to whether they should contract out. For a landlord, contracting out is generally preferable if they have a specific plan for the property, such as redevelopment, or if they're going to sell it, or owner occupation at the end of the term, or they're granting a short-term lease to maintain flexibility, or if they want to avoid the cost and the uncertainty of the renewal negotiations or court proceedings. For a tenant, there's different discussions. They will generally resist contracting out if the location is crucial to their business and its goodwill, or that they want the security of knowing that they can likely renew and stay. They want the right to compensation if the landlord succeeds on certain grounds, a topic for a later seminar. A tenant will typically seek a significant incentive from the landlord, such as a lower rent or a longer initial rent-free period to agree to contract out. The decision to contract out must be made early, and landlords and their agents ought to discuss this before marketing the property and certainly before agreeing heads of terms. They also need to make sure that the heads of terms agreed upon explicitly deal with contracting out. Getting this wrong at the outset can have profound consequences for the landlord's property strategy, its financial position years down the line. And if the decision is to contract out, the three-step process for contracting out must be followed strictly, else the tenancy will have the protection of the Act. It is sometimes the case that parties to a lease first enter into an agreement for lease before entering into the lease itself. An agreement for lease is a binding contract where the parties commit to granting and taking a future lease, conditional upon certain events first taking place, such as building completion, planning permission, or works being undertaken. The landlord must serve its warning notice, and the tenant must serve its simple or statutory declaration before the tenant enters into the tenancy to which the notice applies, or, and this is crucial, if earlier, becomes contractually bound to do so. The contracting out procedure must therefore be completed before the tenant is bound by the agreement for lease, not just before the actual lease is granted. If contracting out has not happened at this point, then it's too late. The lease will have the statutory protection regardless as to whether the contracting out process is undertaken before the lease itself is entered into. It is not uncommon for leases to contain guarantee provisions. A typical guarantee clause in relation to a lease of commercial property provides, amongst other things, that the guarantor will take a new lease of the property for the remainder of the term of the original lease, if called upon to do so by the landlord after the occurrence of one or more specified trigger events, for example, insolvency of the tenant or disclaimer or forfeiture of the original lease. This is referred to as a new lease obligation. If the original tenancy is validly contracted out, it's almost inevitable that the landlord will want any new lease taken by the guarantor to also be contracted out. The question which arises is, when should the landlord carry out the contracting out procedure with the guarantor in order to ensure that any new lease taken by the guarantor pursuant to the new lease obligation does not have the benefit of security under the Act? Well, the answer hinges on identifying when the guarantor becomes contractually bound to take the new lease. The question is it at the point when the guarantee is given under the original lease, or is it only when the landlord calls on the guarantor to take the new lease pursuant to the new lease obligations? There's been no judicial determination on this point, and so out of abundance of caution, the contracting out steps should be undertaken prior to the guarantor given the guarantee in the original lease, and again before the guarantor enters into the new lease under the new lease obligation. It may be that the original tenant under a contracted out lease wishes to assign their lease to a proposed new tenant. In many leases, the assignment will be conditional upon the outgoing tenant entering into an authorized guarantee agreement known as an AGA. An AGA is an agreement whereby the outgoing tenant guarantees the performance of the tenant obligations under the lease by the incoming tenant. It gives extra protection to the landlord and means that they can pursue the original outgoing and incoming tenant if there are breaches of the lease. An assignment is not the grant of a tenancy. Instead, it is the transfer of the rights and liabilities in a tenancy which has already been created. It is not the case, therefore, that the contracting out process needs to be undertaken again in respect of the new tenant. However, that is not the end of the matter. If the outgoing tenant is to provide an AGA as a condition of the assignment, and the AGA contains a new lease obligation, which we covered in respect of guarantees just a moment ago, then prior to the assignment taking place, the landlord will want to undertake the contracting out steps with respect of the outgoing tenant prior to the outgoing tenant entering into the AGA. Finally, I deal with one point which, albeit might appear straightforward, is often overlooked and which will render the contracting out process invalid, even if the process itself was undertaken correctly. Contracting out can only apply if the contractual term of the lease is a term of years certain. This means that the contractual term must be for a fixed period, and the expiration of the contractual term occurs on one fixed date that can be ascertained. The contractual term can be expressed to be by reference to two calendar dates, the start and the end, or can be expressed to be by reference to a fixed period of time calculated to a fixed commencement date. In those examples, the term of years is certain. If, however, the expiration date of the contractual term is not fixed, for example, if the definition of contractual term in the lease refers to any periods of holding over or continuation, then the tenancy is not one with a term of years certain, and it will never be possible for the parties to that lease to contract out of the statutory protection of the Act. That takes us to the end of our first seminar in our commercial landlord and tenant series. Should you require assistance with drafting leases, agreements for leases, or ensuring that the contracted out process is followed, our commercial property team is equipped to support your commercial objectives. You can please contact us if you wish for tailored advice. In our next seminar, We will assume that the tenancy entered into between the landlord and the tenant has the benefit of security of tenure and has not been contracted out. We will explore the ways that the tenancy can be brought to an end using the various mechanisms under the Act. We'll look at the process of serving the appropriate notices, the strict timelines involved, and the common traps for the unwary. All that remains is for me to thank you for joining us, and I hope you can join us on our next seminar. A recording of this session and a copy of the slides will be uploaded to our website. We look forward to seeing you for Seminar 2, the lease termination process under the Landlord and Tenant Act 1954, on the 20th of October.